Hear me now? Working? Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, and I will be your employment lawyer for the next half an hour. You can see my name on the screen. I am an associate at Samfiru Tumarkin LLP, which is Vancouver, Canada's leading employee side employment firm. Okay, listen, I may be having some audio problems. We're just trying to work that out. I hope everybody can hear me. Okay, confirmed. I'm not having any audio problems anymore. Please send me in your questions. I don't have any at the moment, but I expect to get some any minute. While we're waiting for the questions to roll in, there was a famous story on the news. Let's see if I can find it. Famous story on the news recently. Well, I got one question. I'll save the news story for a minute. Okay, so we got a question from Alexander. How long does it take to settle for severance after you speak with a lawyer? Well, that's just. I mean, there's no one answer I can give to that, or any sort of definitive answer I can give to that. It just depends. It depends on how much the employer is willing to compromise, how much you're willing to compromise, how much the employer wants to get something done, how much you want to get something done, and most importantly, the issues in play. So, employment law has in some files what are called fatal issues, and fatal issues are, or at least that's what I call them, and those are issues that can take you to zero. And if there's a fatal issue in a case, such as just cause or resignation, maybe there's an allegation you resigned, you weren't fired, or maybe the employer is saying you committed conduct that is of such an egregiously bad nature that it could fire you without paying you severance, then chances are that matter is gonna go a little bit of a distance. But if there's no possibility of any of that stuff, then no fatal issues in play, then they usually tend to go faster. Where they don't is where there's a lot of money at stake. So if a business, if you're a high income earner making, 200,000 a year, 150,000 a year, or something like that, and you've been there for 15 years and you're in a senior position, the business is going to have to lay out, $150,000, $200,000. They're going to fight you, right? They're going to fight you, even though they probably don't have much of a case, and they're going to push whatever they can push in order to try to reduce that price tag. But if the value of your case is worth $50,000, that might settle pretty fast, right? So it all depends on the different dynamics. But I will tell you this: different employers look at wrongful dismissal matters differently. So there are some employers who most employers, I would say, just look at it as a dollars and cents thing. It's a cost of doing business. Where yes, on the way out the door, you're going to have to pay employees severance, and it's just a matter of where that quantum falls. But others take it personally, particularly when you have a closely held corporation. Maybe one owner owns all the shares in the business, and they view it very, very emotionally. How dare this employee challenge me? And in situations like that, those are the files. Those are the matters that tend to go a lot longer, right? So it depends on, is it an emotional situation or a dollars and cents situation as well? So to answer your question, there's no way I can answer your question. It depends on a variety of factors. Okay, great. I hope that answered your question. Next question. I work for a large car rental company, and no name. And for the last 2 years, my commission has been much less than it should have been. Is this legal? Am I supposed to receive 4%? Okay, so I don't know what your commission. So your entitlement, or the amount of your commission, is going to flow from what your employment contract says. So if your employment contract says you receive 4%, or usually what commission agreements have is some sort of formula, like you get a percentage on the actual collections of X, if Y happens or something like that, right? So usually with commission agreements, it's a situation where there's no discretion. You achieve the target or you didn't, and you get the money, right? So if you've got a contract that says what you're supposed to get and they're not paying you for that, then certainly you'd have entitlement for that money. The question is what you do about it. And the question is how much delta, like what is the value of it? So if they're shortchanging you by $1,000 here or there, and over the course of a year, and it's not worth losing your job over, then maybe you don't do anything about it other than try to get it resolved amicably. And just in general, in situations sort of like this, if you can resolve it amicably with your employer, that's probably the best bet for you, for most of you. But if they're not budging, you're not particularly committed to that job, and you just want that money, and you're prepared to risk the job, then you can, if it's contractual, you could bring a court action for that money. And if it's not, and you've been there for long enough, and this might vary jurisdiction to jurisdiction, and you've always been getting commission of a certain amount, then you could still bring a court action for that unpaid amount, provided, again, it was worth it. You're not gonna sue somebody over $3,000. I mean, you could, but you probably won't, especially not when you won't get a lawyer involved for that. But you could also bring, and this would probably vary province to province, but in BC certainly you could bring an employment standards branch complaint, and then you don't need a lawyer for that. So there are a host of things you can do, but I think the starting point for you is to evaluate. Well, one, where's your entitlement to your commission flowing from? Two, are you sure they're underpaying you? Three, have you tried to resolve it amicably? Like, hey, employer, you're supposed to pay me this money. And if they say, no, we're not supposed to pay it, you've been paid the right amount. And then four, are you prepared to take steps that may sour your relationship with your employer to try to go after that money, right? Like if you're getting paid $80,000 a year and we're talking about $1,500 in total a year, maybe it's not worth it. So those are the four things you should probably think about before you take next steps. But generally speaking, if the amount is small, amicable solution is what you want, because there's not really a solution in play for you that's going to be worth it unless you just trying to get money on the way out the door and you're going to quit anyway. Okay, question from Abby. I just signed a contract that says I have 5 years for no client soliciting or information sharing after I leave. I want to start my own company in the same field in a few years. Am I limited because of this? Okay, so Abby is talking about a restrictive covenant. And so restrictive covenant is something that restrains your ability to trade effectively, but to do something both while you're an employee and after you're an employee. So they come in classically two forms: in employment contracts, a non-compete clause and a non-solicitation clause. Now, non-compete clauses, you cannot compete against the business that was employing you for a period of time after your employment. Now, non-compete clauses are, I'm not going to use the language presumptively unenforceable, but pretty close. So let's just say you make widgets, okay? And you've been making widgets your whole life. You have a 20-year working career and all you've done is make widgets. And you sign a contract with this business that has a 2-year non-compete clause saying that you can't make widgets for anybody else for 2 years. And then they fire you, okay? And let's just say you have a mortgage and 3 kids. Well, all you know how to do is make widgets. And if that employment contract was enforceable, you would not be able to feed your family and pay for and support, make your mortgage payments. And that's a disaster for society. And so generally, the law is not going to enforce this type of restrictive covenant, a non-compete clause. Where it can be enforced is where someone, a very, very senior, a C-suite executive, privy to insider information, and even then it has to be geographically limited. Like it can't be across Canada and North America. I mean, even across the province of Ontario, it's probably too broad. And it has to be limited in scope, what it is that they can't compete in. It can't just be anything, that we do business in, and that the employer does business in. And it has to be temporally limited. So, 2 years, probably too long. 12 months, probably fine. 2 years is probably a fine too in limited circumstances, but beyond that, no. So, okay, but that's not what you're asking. You're asking about the other flavor of restrictive covenant, which is non-solicitation agreements. Now, non-solicitation agreements are presumptively enforceable, and they come in two sub-branches. You can't poach employees from your previous business, and you can't poach from your employer after you leave for a period of time, and you can't poach clients from your employer from your employer for a certain amount of time. Okay, so these are presumptively enforceable, and often non-compete clauses are written down to be non-solicit clauses because it makes sense. The business doesn't want you, who's privy to proprietary information, to steal their employees and clients after you leave. And so these are presumptively enforceable. Where they become unenforceable, and this varies, I think, from province to province. Some provinces, their courts are a lot more employee friendly about this than others. But where they become unenforceable is if they're too broad. So if they're purporting to cover, say, any potential client, or if it would go on for too long. So 5 years, that's probably too much. But you got to understand the substance of what you agreed to, Abby. You said, I'm going to work for you, and I'm not going to steal your clients afterwards. And what you're saying is, but I want to steal your clients afterwards. And so there's no neat reason why when you set up your own business, you have to steal their clients. But is 5 years too long? Probably. But if within the first 12 to 24 months you start stealing their clients, you're probably dead in the water. And I will say this, without looking at the clause itself, the spirit of it, though, is if you're doing the thing, even if you can get around the technicalities of the contract, if you're doing the thing that you promised not to do, court's not going to want to help you. Now, here's the thing, the important thing. When you're talking about violating a non-solicitation agreement, i.e. you've promised not to steal your former employer's clients, the remedy is disgorgement, okay? That is, so you set up your own business, it's 100% dependent on the revenue of the clients you stole, and then your former employer sues you, and its remedy is to take all of the profits you got from the stolen clients and give it to the employer, which effectively puts you out of business. Okay, so it's a very, very serious thing. And I would advise anybody in this type of circumstance, if you're subject to a non-solicitation agreement, you want to make sure that you've clearly and you start a new business, you clearly ring-fenced your old business, your old employer, so that there's no way that you could be construed as being stealing their clients. Now it's different if those clients come and call you out of the blue. You're not actively going out and poaching them, or if you have, it gets a little muddy if you have other partners who aren't subject to the agreement and they do it. As long as you've ring-fenced yourself away and had nothing to do with that client information getting to those other business partners, you might be okay, but you might be in for a dogfight of a lawsuit as well, right? And remember, the remedy is you're out of business. So take it very, very seriously. And honestly, Abby, I think that you should get legal advice on that, both on the non-compete and what happens when you start your own business. Certainly, we can help you interpret the non-compete, non-solicit. We can help you interpret the non-solicit clause. If you want to give us a call, you can do so. You can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, next question. Employer wants me to sign a new contract. I'm not gonna say this person's name because it's kind of unique. I've been with them for 8 years and have changed positions a few times. Should I be worried about signing this? Anytime your employer asks you to sign a new contract, you should be worried about it, and you should seek a lawyer. You should speak to a lawyer right away. Okay, so for 99, I'm estimating here, but for about 99% of you, 99% of employees, an employment contract is not for your benefit. I mean, generally, it's not for your benefit anyway. But what an employment contract is an employer exploiting its superior bargaining power over you at the time of contract formation to force you to agree to terms that you are bound by that are contrary to your best interests. That's what an employment contract is. It's there for your employer's benefit, not for yours. And there are lots of different things that can be in it that have value to the employer, but the primary one that they're trying, generally speaking, that they're trying to, the primary liability they're trying to limit there is their severance liability to you in the event that you've been terminated. Okay, and so if you get common law severance upon your termination, that could be as much as 24 months of your pay, okay, which is a substantial amount of money. But if they can limit it, and they want to limit it to the statutory minimums, that's just 8 weeks. If you're provincially regulated, it's just 8 weeks. And so, and vast majority of you are provincially regulated. So there's a huge discrepancy in value here, and if your employer, gives you a $2,000 raise, but takes away your ability to get common law severance, that's not worth it for you to sign the contract. For many of you, like, so for example, in your case, if you've been there for 8 years, I don't know what your wage is, but you've been there for 8 years and you've never signed an employment contract, it could be you're giving up, and I don't know your age either, but it could be that you're giving up, say, 10 months of severance in exchange for 8 months or 8 weeks in the event of your termination. And what are you getting back? Maybe a $1,000 signing bonus, or a $2,000 raise, or something like that. Like, it may not be worth it, but the problem is, if you refuse to sign it, your employer has an election at that point to make. One, fire you then and deal with the hit now as opposed to later. Two, I guess give you working notice. Yeah, I mean, I could fire you with working notice. I could say, we're going to fire you in 8 months or 10 months or whatever it is, and that'll be your last day. And then you'd have no severance entitlement. Or three, they could just, and this is probably the most common, they'll just say, oh, okay, and they'll just let you continue on business as usual. But you got to understand and be prepared for, if you say to them, I'm not signing that, those are possibilities that could arise. So you have to be prepared for that. And I'll just call you B. B, you should talk to an employment lawyer. You should talk to an employment lawyer right away before you put pen to paper and sign that. Again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, let's keep going. Stephen asks, my uncle has been working full-time for a telecom company for 20 years. Started collecting a pension about 4 years ago, but was still working full-time. He was just let go. Would he be owed severance still? So he started collecting his pension while he was working. I don't know anything about that. But if he was working for, I don't think that matters. I think what matters is he works for a federally regulated business and he was let go, and he was working full time. He's been there for 20 years. Yeah, no, you need to, yes. I mean, the short answer is he's federally regulated. So there are 3 options that he can follow. He can, 2 options, and one of them trees off into 2 sub options. So he can file an unjust dismissal complaint. He's got 90 days to do that. So, Stephen, you need to talk to an employment lawyer immediately. And don't sign any release from the company. If you did already, it could be you have no claim. And that goes for everybody. If you've been let go and your employer says, hey, sign this release in exchange for whatever it is they're putting forward, generally speaking, do not sign it until you've had a chance to talk to a lawyer. Because if you sign it, your claim is done. Okay, most of the time, your claim is done. And so you might have just signed away 90% of your severance value. So talk to an employment lawyer right away. There are many, many available. You can always reach us, and Stephen, you should contact us immediately, or your uncle should. Again, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Back to the remedies. If it is a telecom your uncle works for, then you have 2 remedies. 1, file an unjust dismissal complaint within 90 days. That trees out into 2 sub options. One is eventually your uncle can get back pay, which I believe runs from the date of termination to the date of the hearing decision, which is like severance, lost wages. It's the same thing. It functions the same way. Or second option, reinstatement. And reinstatement is powerful if they've let you go, powerful leverage, because if they've let you go, they don't want you back. And if they're forced to take you back, it doesn't happen that often, but it certainly can, and it is scary for the employer. So those two options, I would do that right away. It's the best process. But also, under Wilson and Atomic Energy, you can file an action for severance, and if you miss that 90-day window, you can still do that. So, but Stephen, within the 90 days, you're going to want to talk to an employment lawyer. Do it right away. Sounds like you have a great claim. So call one right away. And again, you can reach us at 1-855-821-5900. And yes, I don't understand, and I'm not going to answer at all the pension piece. I don't understand why he'd be working and collecting a pension. I don't know if it's the Canada pension because he was over a certain age, or if he's collecting a pension through the telco, his telco pension, but still working. And if so, is there any sort of offset? I don't think so, but I don't know anything about that. Okay, Jackie asks, I've been employed for 42 years with the same employer. Wow, that's very impressive. We've been offered hybrid hours, 2 days and 3 days, work from 2 days at home, work 3 days, work from office. Can they change this to work full time? I don't understand the question. So it sounds like you were working full time in the office or full time at home, and now they've said, well, we want you to work a split, right? And we want you to work from home some days and in the office some days. And the question is, do you have any sort of legal action? And so Jackie follows up and says, well, would I be entitled to severance if it doesn't work out for me and I have to leave, retire? Well, listen, Jackie, if they're taking you from part-time to full-time against your will, you may have a constructive dismissal claim there, depending on what is the reason for you working part-time. Schedule changes are really hard. Like, constructive dismissals generally are hard, right? The risk is higher because you have to get a court to agree that the actions of the employer either breached a fundamental term of your employment, or that the employer's actions repudiated the contract, such that the judge sitting in your position says, I couldn't have worked there either. They've repudiated the contract. She's effectively been terminated. Okay, so but you have to get a court to agree to those things, and that's hard to do because of sort of the underlying policy dynamic of employment law tends to be full employment. So why would a court say, oh, you've been de facto terminated when you've got a job and you're earning money, unless, of course, there was a clear reason, like the employer was clearly trying to get rid of you or force you to quit, or they lowered your wage by 25%. But in a situation of schedule changes or something, it certainly can happen. It depends on what your reason is. So if you've got elder care or child care responsibilities, and that's why you're on a part-time schedule and you can't work a full-time schedule, certainly that could get you there. With respect to the hybrid stuff, though, right? Like, let's just say that the common question I get is, they moved me to work from home during the pandemic. I've been working from at home for 3 years. I like it. Now they want me to come back to the office, either full-time or in a hybrid role. I don't want to do that. Do I have a constructive dismissal claim? The answer is no, you don't. Particularly for those of you who worked in that job before the pandemic. I mean, the pandemic was a temporary aberration. Employers did what they had to do, have you work from home. But you have no legal entitlement to be there, and I think the law has been fairly clear on that. So no, if that's the substance of your question, no, you don't have a claim. You're going to have to you have to quit or keep working there. Now, it's different. I mean, you've been there for 42 years, so that's my final answer on that. But it's different for people who were hired specifically to work from home in the middle of the pandemic, right? So depending on what the nature of what the contract says about that, if it's silent on it, there very much could be an implied term in that contract that says, well, no, I was hired to work from home, and if you want me to work in the office, you're going to have to provide me with fresh consideration. I'm going to have to agree to it, or I don't agree to it, and you're going to have to fire me. And if you force me to go to the office, it is a constructive dismissal. Now, I think there's an argument there. I don't think that would be my favorite case to run to court, but I certainly think there's an argument there. Stephen asks again, you mentioned a signing bonus earlier. When will you receive a signing bonus? Okay, so it's a great question. In order for an employment contract, a written employment contract, to be valid, well, let me put this a different way. Whenever there's an agreement between two parties, in order for the agreement to be enforceable, so that's what a contract is, fresh value has to go in both directions, right? So in the case of an employment contract, you're limiting your rights by signing the contract in exchange for the job, right? So fresh value is going in both directions. But from then on, you are in perpetuity working under effectively the arrangement of I give my labor in exchange for money, okay? And so if the employer wants to make any changes to your employment contract, the four corners of your employment contract, it has to give you fresh value for you relimiting or agreeing to new limits on your rights. And so it can do that. Fresh value can be anything. It can be the opportunity to earn more commission, more vacation pay, a raise. Quite often it's a signing bonus. Now, the law doesn't care how big the value is, although it's kind of mixed on that one. It just has to be value. So if they say, we're giving you $100 as a signing bonus for signing this contract, probably valid, although there's public policy considerations around the fact that the employee is giving up a ton of rights in exchange for $100. But I certainly wouldn't like to run that one to trial. And so you got to look at exactly what value they're giving you. And so yes, quite often employers will say, okay, well, here's a signing bonus for this contract to be effective. Here's $2,000. But Stephen, in your particular fact pattern, if they're giving you a small signing bonus in exchange for giving up 15 months of severance, that's paltry compensation. So Jeff asks, what does it take to prove a wrongful dismissal if your employer alleges they had reason to let you go but it was untrue? So it's also a great question. By default, you get severance. Now, the amount of the severance varies on what your employment contract says, and if you are entitled to the bigger severance, to common law severance, than your age, length of service, and your position. But the employer can give you zero if you committed if it had just cause to do so, and that's where the employer where the employee has either done something so egregious on a one-time basis that the relationship is irreparably harmed. You punch your boss in the face, you steal, commit fraud, you're high at work on drugs, that kind of thing. But it's a really high bar, right? And the longer you've been there, the higher the bar is. So that's a hard one to get there. The other one is sort of the progressive discipline, 3 written warnings and you're out kind of thing, although it doesn't have to be 3, but you get the idea. If the employer is trying to manufacture something, like where they gave you 2 written warnings in the span of a week, like that you need clear warning and opportunity to correct the supposed problematic conduct and or behavior. So if it's just you didn't have progressive discipline, Jeff, and they just let you go, they said we had just cause, and here's why, or even if they didn't say it, depends on the severity of the thing that you did, right? So if it was a physical altercation with your manager, yeah, that might get you there, right? But if it was, you made a mistake on a purchasing order, probably not. Although famously in BC, there was that fellow who he worked for a winery and he spilled something outrageous, like 24,000 gallons of wine that cost the business millions of dollars out onto the floor. And I think it was the second time he did it, but they were many years apart. And they fired him for just cause in the court. I think there was a court decision that upheld it, but I can't remember. But yeah, that it can be, just for simple mistakes, it can be cause. We're almost done. Jackie says, again, she's the one who's now having to work partially from the office, partially at home. Prior to COVID, we were full-time in the office. Do they need to give us notice if they change the hours? So for the first part, yes, they can bring you back to work a hybrid role and that's just the way it is. And your only election is going to be, or if you need a solution, the only solution you can find would be an amicable one with your employer, like if you negotiate something. But employers are quite often are going to a hybrid situation, and there's really not much you can do about it, particularly in your situation because you were there for 42 years. They need to give us notice if they change the hours. Depends how radically they change the hours, right? So if they're moving you from the 7 a.m. shift to the 8 a.m. shift, no. But if they're moving you from day shift to graveyard, probably that probably is a constructive dismissal, particularly at the older you are, because I think it's very hard to work graveyards the older you are. But it depends how radical the change is, right? And so but at the end of the day, Jack, you've been there for 42 years, right? Like, are you trying to get money on the way out the door because you're going to quit anyway? Or is this a situation where you need the job and it's all you know and you want to continue working there, in which case you need to preserve the amicable relationship? So, Jack, he'll just say, like, don't do anything. Constructive dismissals are hard. Don't do anything without talking to an employment lawyer. You need to do that. And you can always reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855 821-5900. There's one last question. Joseph asks, there were two men were fighting at work. Company didn't fire them. Two of them got verbal argument. They fired them. Is that discrimination? If the reason why they were fired was because they were women, then yes, it would be. But I think trying to compare apples to apples, and saying, well, the men did the same thing and they weren't fired. You can make that argument before a human rights tribunal. I don't know if you'll get there, because it's the substance of the thing they did that matters, right? So if they were screaming and swearing in the office, then the company might have said, yeah, we got to get them out of here, right? So, I take your point. Is it sort of latent discrimination? It might be, but convincing a tribunal that that's overt discrimination might be a difficult road, but you certainly might want to explore a human rights complaint. So, okay, that's it. Great questions today. Again, if you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. I will be back, I think, in 2 weeks in the same time slot, but you can join us live on Monday, 1:30 p.m. Eastern Time with Chris Justice, who will be laying down the law on all things employment law. It'll be a great session. Please join us for that. I hope everyone has a wonderful and safe weekend. Thank you for the great questions, and have a good day.